to chair this session on like Asia's role in international arbitration. So first of all, I want to apologize that one of our speakers could not join us today for some unexpected reasons. So for today's session, we're going to have only two speakers, but these two speakers are really, distinguished experts in international arbitration with very rich experience and practice in this field. So the two speakers are going to share their perspectives and insights on international arbitration, first of all, in their respective jurisdictions such as Korea and Singapore. And we will also compare from a regional perspective how the Asia's role is going to have some impact to the other parts of the world. So today we are going to have two presentations by two speakers, and after the presentation we will then have a Q&A. So given that we have very large number of participants for this event, so if you have any questions to the speakers on this topic, please leave your questions in the chat box, and then I will pass these questions to our speakers in the Q&A session. So before I hand over to our speakers, I'm going to give a very brief introduction of these two speakers. So we will first have Ms. Violet Huang, who will be the first speaker to speak for the first 20 or 25 minutes. So Ms. Huang specialized in general commercial arbitration, litigation, international arbitration. She is a Singapore and PRC qualified lawyer. Her career highlights include serving as a justice law clerk at the Supreme Court of Singapore and working in the international arbitration team of a prominent international law firm. She has strong background in prosecuting financial crimes as a former deputy public prosecutor at the Attorney General's chambers. She's also an accredited mediator with the Singapore International Mediation Institute. So currently, Ms. Huang teaches constitutional law and administrative law at the National University of Singapore. So, and our second speaker is Ms. Joanne Bay, who is a senior associate in Bay, Kim, and Lee LLC's International Arbitration and Litigation Group. Joanne is a Korean qualified lawyer who focuses on international dispute resolution, including international arbitration and cross-border litigation. Joanne has acted as counsel in various international arbitrations conducted under the auspice of the LCIA, ICC, VIAC, as well as in ad hoc cases under the UNCITRAL arbitration rules, which involved complex commercial disputes concerning intellectual property, insurance, post-M&A issues, and construction disputes. Joanne also regularly represents clients in related court proceedings. Thank you very much, Viola and Joanne, for joining us. I really look forward to your presentation. So now, without further ado, I'm going to hand over to Viola for the first presentation. You can share your screen now.
Thank you very much, Yumi, for the introduction. Is everyone able to see my screen? Okay. So today what I'm going to talk about is the recent test of arbitrability at the pre-award stage in Singapore. So that's the case of Anupam Mittal and Westbridge Ventures. So for ease of reference, I will call it the Westbridge 2 CA judgment. So this was published in 2023, but it was one of the first decisions, I would say, to determine what should be the test to determine if a matter is arbitrable, like which law should apply at the pre-award stage. Because I think, as we will discuss later, at the post-award stage, the test is relatively clear. But the Court of Appeal had the chance to deal with this test at the pre-award stage. So first, the anterior question is, what is arbitrability? So arbitrability, as some of you students of arbitration would know, it's about whether a subject matter can be resolved through arbitration. And national laws would differ on this. For instance, national laws may determine that a certain class of contracts, such as consumer contracts, for the reason of consumer protection, should not be determined by arbitration. Or national laws may determine that certain disputes like trust disputes or intellectual property disputes, which might involve third-party interest should not be resolved through arbitration. So this is really a matter that's carved out for different national policy. And I'm not here to talk about what is arbitrable and what is not arbitrable. I'm here to talk about what law, the logically anterior question of what law should determine that question to begin with. So in terms of looking at the statute in Singapore, which I think would be quite similar to what there is in Hong Kong as well. So in Singapore, there is the International Arbitration Act in Singapore. So the scope of this act governs international arbitration. So for instance, if it's purely an arbitration between a domestic party in Singapore, that would not be under the International Arbitration Act. So looking at Section 11 of the IAA, International Arbitration Act, Singapore. It's titled Public Policy and Arbitrability. So any dispute which the parties have agreed to submit to arbitration under an arbitration agreement may be determined by arbitration unless it's contrary to public policy to do so. So there are two questions here. First is this an overall provision? Does it apply to all arbitration seated in Singapore? Does it apply to any arbitration proceedings that come before Singapore court? So this is really, I suppose, the provision for arbitrability in Singapore that, yes, you can do it by arbitration. It's a very pro-arbitration forum, unless it is contrary to public policy. Then the second question is, what is public policy? Is it public policy of Singapore, or is it foreign public policy, or is it some kind of a notion of international public policy, as some of you might have known from taking conflicts of law classes, that there is a doctrine of international comity, international public policy, as you can see in the Iran line of cases. So that's the provision we have in Singapore. So at the post-award stage, it is quite clear, based on the ancestral model law at Article 34, subsection 2A1, that the law of the arbitration agreement determines issues relating to the validity of the arbitration agreement. So that you can see it's quite clear. Or the said agreement is not valid under the law to which the parties have subjected it to. So that typically we would say that so this goes back to one of our fundamental principles, right? So there is the separation between the agreement and the arbitration agreement. So the arbitration agreement is standalone, and it's the law of the arbitration agreement that should determine whether the arbitration agreement itself is valid or not. However, Article 34, it only deals with the issue of setting aside. So that's post-award stage, but it doesn't really tell us what to do for the pre-award stage. So for some of the participants, you may think, actually, from a logical point of view, there is no reason why the law applicable should be different at the pre-award stage or at the post-award stage, because we're just talking about the same arbitration, right? So you would think that actually the law applicable should be the same. Doesn't matter if it's at the post-award setting aside stage or at the pre-award stage. So in the case of Westbridge too, the key issue is precisely that. So at the pre-award stage, should the seat court, which is the seat is in Singapore, apply laws other than the lex fori, the seat law at the pre-award stage? So, okay, now we can pause and think about what possible laws there can be to govern this arbitration, to govern the issue of arbitrability. So first, you have the law of arbitration agreement. The reason why I put a question mark there is sometimes it's just not clear based on all the commercial contracts you've seen. It's just unclear to us what is the law of arbitration agreement. Like parties just don't stipulate. They leave it. They either provide the law of the agreement and the law, what is the seat, but sometimes they don't really stipulate what is the law of the arbitration agreement. So that is a big question mark. The second possible law that is always clear is the law of the seat, right? So not always, but most of the time it's pretty clear. It's the law of the seat. So these are the two possible laws. And perhaps can there be third options, other options? I leave it to you to think and reflect. Maybe there is a third way besides the two possible laws that can govern the issue of arbitrability. So the background of Westbridge 2, so the facts are not exactly relevant, but I'll just go through it. So for the sake of context. So the plaintiff in Westbridge is Westbridge, Mr. Mittal. And the defendant in this, they were both shareholders in a matrimonial service company incorporated in India. So as far as we are concerned, the shareholders, the companies, everything is in India. So the shareholders of the company entered into a shareholders agreement, which is governed by Indian law. But the arbitration clause itself provides for the arbitration of disputes. So I quote this precise wording is relating to the management of the company or relating to any of the matters set out in the shareholders agreement. So this arbitration clause applicable to this class of disputes only is seated in Singapore. And as we have mentioned, sometimes parties just don't say what's the law of the arbitration agreement because that's kind of like at the backseat of their mind. So the arbitration clause here is indeed silent on the law of the arbitration agreement. And as we have seen in disputes, what happened is that the shareholders' relationship deteriorated, and Mr. Mittal brought an action for corporate oppression in the Indian court against the other shareholders, including Westbridge. So Westbridge filed an anti-suit injunction in Singapore on the basis that there was a valid arbitration agreement. So this suit in India should be, or rather, they should be stayed from proceeding on the Indian proceedings so that they can focus on the arbitration. So what exactly is the conflict here? The conflict here is what law should apply to determine the issue of arbitrability. And when we look at the substantive conflicts, so the parties' argument are quite straightforward. So one is under Indian law, there is expert report to say that actions pertaining to corporate oppressions should be submitted to Indian courts. So it's not arbitrable. Under Singapore law, there is no such prohibition, so it is arbitrable. So in the High Court decision, the court held that the arbitrability issue at the pre-award stage should be governed by the same law that applies for the post-award stage, which is therefore the law of the seat of arbitration. And the court also interpreted, if you remember, we took a look at Section 11 of IAA. It talks about contrary to public policy. So the view of the High Court is that public policy only refers to public policy of Singapore rather than foreign public policy. And perhaps you might be minded to agree with the High Court that yes, what other public policy can there be? Because the Singapore Parliament is not to legislate for the public policy of other countries. So the High Court therefore found that there is no reason for the Singapore court to apply a foreign law, meaning India law, in order to determine whether the subject matter is arbitrable. So in Singapore's court system, there is sometimes this person called amicus curiae, which is now called the independent counsel. So they are some sort of court-appointed legal expert to also submit their independent view on the matter, especially when there is an issue of law. So in this case, we also have an independent counsel who agreed with the High Court judge that the law governing the issue of arbitrability at the pre-award stage should be the same as the law for the post-award stage. So that's one side of the view. That's the High Court's view, and that's the independent counsel's view. Now we're going to move on to what the Court of Appeal has found, which is to come up with a more novel test of the composite approach. So the court's criticism of the High Court's opinion is that there is insufficient weight given to foreign public policy. So if parties really want to circumvent the application of a foreign law, they can very well just put the Singapore law as the seat, and they can circumvent any foreign laws that preclude arbitration. So that is sound reasoning. I understand where it's coming from. So then the court said Section 11 of the IAA cannot just be confined to Singapore public policy, but extends to a foreign public policy where it is relevant to the essential elements of an arbitration agreement. Then the question is, what is that foreign public policy? Do we have to look around the world? So that's where the court said, yes, we have to look at the law of the arbitration agreement, because law of the arbitration agreement governs the validity of the agreement. It is what the court said, the font of the tribunal's jurisdiction. So first, the composite approach is that not only should we apply the law of the seat, we should also apply the law of the arbitration agreement. So the first stage, the court applies the law of the arbitration agreement because it's the font of the tribunal's jurisdiction. It determines matters of the validity of the agreement. But that's not enough. The court said, second, we have to apply the law of the seat. This is because at the post-award stage, the arbitral award will be set aside if it is not arbitrable under the law of the seat. So to save everyone time, let's look at it at the pre-award stage as well. So to summarize, the composite approach basically means we have to go through like a double-barreled test in order to determine whether a dispute is arbitrable. So first, we have to look at what the law of the arbitration agreement, and next, we have to look at law of the seat. So perhaps you might agree with the court's reasoning that this covers the notion of foreign public policy because law of the seat is not the only applicable law to determine whether an arbitration should or should not be arbitrable. However, what I want to point to you next is how do you determine the law of the arbitration agreement? So in Singapore, the test is set out in Sul America. I believe this test doesn't differ too much across the common law jurisdictions, but please correct me if I am wrong. So basically, it's a three-stage framework. Okay, it might be a bit different in the UK. So it's a three-stage framework. So first, you look at parties' express choice. And as mentioned, parties don't usually choose the express law of the arbitration agreement. Second, they will look at parties' implied choice. And third, if they can't even find, if they can't find either the express choice nor the implied choice, then it's the system of law which the arbitration has the closest and most real connection to. So if we could just pause here and think about what's the practical impact of applying this test to determine the law of the arbitration agreement. Let's suppose the court is looking at, in the Westbridge case, you have one dispute that's governed by Indian law, but parties have chosen to submit to the jurisdiction, to submit to SIAC to be governed. The seat is in Singapore. Then the question is, which one between India, Singapore, which one has the closest and the most real connection? And the end result is, it tends to be the case that the law of the arbitration agreement is the same as the law of the seat, because the court's reasoning is that if the parties have intended for this matter to be arbitrated, surely you would have chosen a law that allows this matter to be arbitrable. So we go back to the same circle that in the end, it may not make any practical result whether we're applying the composite approach or applying the singular approach of applying the law of the seat. For instance, I'm just drawing out the possible outcomes here. We have law of the seat equals to law of the arbitration agreement, same result. The only difference it makes is if the parties provide specifically for the arbitration agreement to be governed by a different law, then that might make a tangible result, difference in the result. So here are some of the tentative views of the court's approach, which may or may not be correct, but these are just some tentative views of mine. So first is that because the law of the arbitration agreement might coincide with law of the seat, and because of the court's reasoning that the law of the arbitration agreement surely must be a law that allows parties to arbitrate. Because of that, it does not necessarily address the issue of comity and foreign public policy. So if the seat court thinks that Singapore law allows it to be arbitrable, India law does not allow it to be arbitrable, surely parties must have intended. So the conflict here is more fundamental. The tension is that the doctrine of arbitrability overrides parties' consent, because it is a public policy of the state that dictates whether something should be arbitrable. But when we apply this test of law of the arbitration agreement, we still uphold the fundamental principle of party autonomy, which stands at odds with this notion of arbitrability as a public policy tool to counter party autonomy. So ultimately, we're still looking at a rule that favors party autonomy, and that may not adequately address the issue of foreign public policy. And two consenting parties, as we can see, as the result of Westbridge, you can still choose to circumvent a mandatory rule of non-arbitrability in India by favoring a different legal system to govern the arbitration agreement. So these are just some tentative views on the court's approach. And I believe that this is relatively a novel issue. But based on my brief research, I think in the UK, we have a different case where the court opined that it was an obiter, that it would be illogical if the law governing the validity of the arbitration agreement were to differ depending on whether the question is raised before or after an award. So they favored the approach tentatively. They favor the approach of consistency of applying the same law, which means law of the seat, both for the pre-award and post-award stage. But we can see this more novel approach in Singapore, which has this good intention of addressing the issue of foreign public policy, international comity, but it is questionable whether this composite approach is truly able to satisfy that concern. And that is the end of my presentation. I welcome any questions. Yumi, I think you're on mute.
Yeah, thank you very much, Valerie. So thanks a lot. So we're going to have second presentation, and then we reserve the questions for at the end of this at the end of this seminar, right? So Joanne, could you please unmute yourself, and then I'm going to leave the floor to you.
Hello, everyone. Can everyone see me? Okay, wonderful. Let me just pull up this. Very good. Thank you, everyone, for joining us for this seminar. My name is Joanne Bay, and I'm a senior associate working in the International Arbitration and Litigation Group in Bay Kim and Lee in Seoul, Korea. As Yu Ming said, I'm a licensed Korean attorney, and my practice is primarily focused in international arbitration and cross-border litigation. Now, what I wanted to discuss with you today is the issue of privilege. I don't have slides like Violet, but if you can bear with me and follow my discussion, and please feel free to raise any questions in the meantime. Okay. So as most of you would be aware, most countries recognize the concept of legal privilege, which is a right to protect from disclosure communications between lawyers and their clients and documents prepared for the purposes of litigation or arbitration or adversarial legal proceedings. And as you may also be aware, different legal jurisdictions have different approaches to legal privilege. And in fact, the nature, the scope, and application of privileges can vary quite significantly from jurisdiction to jurisdiction. So that means that what's accepted as privileged in one country will not necessarily be privileged in another country. Now, this is perfectly fine when we're conducting a dispute in just one jurisdiction. But of course, these variances in privilege rules become particularly important in international arbitration. Because for one thing, as you are all aware, most international arbitration proceedings involve document production. So issues of privilege arise in nearly every case where parties dispute which documents should be excluded from disclosure from the get-go. And furthermore, international arbitration cases are necessarily cross-border in nature, with multiple interplays of different legal or ethical systems. So, and parties also usually come from different legal backgrounds, and so do their respective counsel. So there can be very different expectations of privilege from the beginning of the dispute. So in this context, I wanted to first go through some of the basic privilege rules accepted under different jurisdictions. I think you would be much better, much more familiar with common law privilege rules, but just bear with me and let's just go through some of the basic rules first, and then I would like to go on to introduce legal privileges that are currently accepted under Korean law and what kind of discussions are developing in Korea in terms of privilege at this moment. And then as a final point, I wanted to briefly address how legal privilege in relation to international arbitration cases with Korean aspects are treated in practice slightly differently in terms of the scope of privilege rules to apply. Okay, so to begin, a simple and general summary of privilege rules in different jurisdictions. I'll quickly deal with English common law systems, the US law system, and civil law systems, just as three broad categories. So you would be best aware, as far as I understand, under English or common law systems, there are three main types of legal privilege: legal advice privilege, litigation privilege, and without prejudice privilege. I'll go through one by one very briefly. So the first one, legal advice privilege, is a privilege that ensures that communications between lawyers and their clients done for the dominant purpose of giving or obtaining legal advice is protected from disclosure. Now, I understand that this privilege is absolute and not easily waived, and also applies to in-house counsel as well as external lawyers. The second category of privilege, litigation privilege, extends to documents created when there is a reasonable prospect of litigation, arbitration, or other adversarial proceedings. This privilege extends to documents created by other parties like technical experts and professional advisors who are not attorneys, as long as the document was created for the dominant purpose of the litigation, hence the name litigation privilege. And lastly, the without prejudice privilege attaches to any communication between the parties made in a genuine attempt to settle the dispute and renders that communication as inadmissible. So that is the privilege rules, broad privilege rules accepted under English or common law systems. Now, under US law, I understand that it's a little different, and it can also vary. The precise rules of privilege can vary from state to state. But for now, we'll deal generally with two broad categories of privilege accepted under US law, which I understand is attorney-client privilege, also referred to as ACP, and work product protection. The first attorney-client privilege, I understand, protects confidential communications between attorneys and their clients made for the purpose of seeking or obtaining legal advice. So in this sense, it's similar to legal advice privilege in common law, but in certain states, I understand, it can be broader in scope by attaching to communications for even legal advice for communications for which, even if the dominant purpose is not legal advice, as long as it is legal advice is one of the purposes, ACP attaches. So that's different from legal advice privilege under common law. Second, work product protection is similar to litigation privilege under common law and shields materials prepared by or for an attorney in anticipation of litigation from being discovered by the opposing party. So unlike litigation privilege under common law, however, work product protection distinguishes between documents organized for the litigation and materials that reflect an attorney's opinions and conclusions. And the latter, the materials that reflect an attorney's opinions and conclusions, I understand, are afforded greater protection under work product protection. Now, as for without prejudice privilege under common law, there doesn't seem to be a standalone corresponding doctrine under US law, but there is a narrower protection for settlement offers and statements made during settlement negotiations, rendering them inadmissible for certain purposes. But this, of course, contrasts with without prejudice privilege under common law, which provides a broad protection generally for settlement communications and renders them generally inadmissible. Now, lastly, in civil law systems, this is quite different from the aforementioned two legal systems. In civil law systems, disclosure or discovery is much more limited than in common law systems. So consequently, most civil law systems did not establish specific rules of privilege to protect documents from disclosure. Instead, civil law systems, most of them developed a doctrine of professional secrecy for lawyers, obliging them to keep secret all confidential information obtained as a result of their professional relationship with their client. And also, most civil law systems have not evolved a legal privilege corresponding to without prejudice privilege or a settlement privilege. Now, just to then go on to the Korean law and privileges accepted under Korean law, you may be aware that Korea is a civil law jurisdiction. So the characteristics of civil law systems that I just described applies to Korea. And just to go through the more detailed aspects of Korean law and how it deals with privilege. Under Korean law, there's no set discovery phase in Korean civil procedure. So instead, if a party needs documents from a third party or an opposing party, that party can file a motion for a court order to oblige the person holding the document to produce it. Now, this principle is encapsulated in the Korean Civil Procedure Act. And the scope of the documents which the applicant can request to the document holder is quite wide. In fact, a party may request any documents except the following three categories. First exception is documents that may cause a criminal prosecution of family members or relatives. Second exception, documents that contains professional secrets of lawyers or doctors. And the third and last exception is documents for the exclusive use by its holder. Now, regarding the interpretation of the second exception, which is documents that contain professional secrets of lawyers or doctors, for that matter, it literally applies only when the request is designated to the lawyers or the doctors. And this exception does not apply when the request is made to clients who consulted with those professionals. So accordingly, under this literal interpretation, clients, when requested, are not exempted from the obligation to disclose any documents containing discussions with their lawyers in accordance with the court order. Now, this is kind of balanced off because in relation to consequences for failure to comply, in Korean civil proceedings, if an opposing party refuses to disclose documents ordered by the court, or if the opposing party destroys the documents to prevent usage by another party, then there is a provision which allows the court to hold adverse inference against the non-disclosing party. And adverse inference, as you will be aware, will mean that the court will accept the allegations of the applicant party concerning what the document in question shows. This is part of the Civil Procedure Act. However, and importantly in practice, courts rarely have held adverse inference against the non-disclosing party. So consequently, there is very little practical deterrence effect to prevent parties from failing to disclose documents in civil proceedings. Now, separately, if it is a third party which refuses to disclose documents in a civil proceeding, all the court can do is set a fine for up to 5 million Korean won for violation of the order. So it's a slap on the hand. So in civil proceedings, if subjected to a court order to disclose unfavorable or sensitive documents, parties have been known to simply respond that they do not have those documents, and it is very difficult for the opposing party to prove otherwise. If they haven't seen the actual documents in question, because the applicant under Korean law has the burden of proof to show basic so the gist of what the document will contain, where it why the document will be held by the opposing party, things like that, details that it may not be privy to before being actually disclosed the document. It is very difficult for the opposing party to prove something that will have the court hold adverse inference against non-disclosure by the opposing party. Now, separate from document disclosures, as to witness examinations in civil proceedings, attorneys have corresponding confidentiality obligations and have the right to refuse to testify in court concerning professional secrets obtained from communications with the client. So this is another safeguard which protects kind of attorney-client communications under Korean law. However, things become slightly different in criminal proceedings. Attorneys still do have the right to refuse seizure of articles held in his or her possession containing the client's secrets, and also have the right to refuse to testify in respect of facts obtained from a client in a professional relationship. However, those rights include a major exception, and that such rights will not be effective in the event the article or testimony is deemed necessary for important public interest. Now, consequently, in criminal proceedings, authorities have often searched the premises of parties and even attorneys, for that matter, and seized legal opinions and attorney-client communications regarding important cases. In fact, major Korean law firms, including my firm, BKL, has been subjected to such search and seizure by criminal authorities in the last 5 years, which was highly publicized and highly criticized by the Korean legal community. So against this background, the hotly debated issue in the Korean legal community now is among the legal privileges, I think something that was considered the most basic by Korean lawyers is to establish attorney-client privilege and by extension work product privilege through law. Now, there have been attempts by the Korean legal community, and the reason behind the current kind of push for this need is because those efforts have been kind of thwarted by the Supreme Court. Specifically, in 2009, just to jump back, under Korean constitutional law, everyone has the right to receive the assistance of attorneys in criminal proceedings. And from that provision, some practitioners have tried to deduce a right of attorney-client privilege. And in 2009, the Seoul High Court attempted to affirm the existence of a common law style attorney-client privilege in a particular case involving criminal proceedings. But this was ultimately dismissed by the Korean Supreme Court. In fact, the Supreme Court in that case held that a common law style attorney-client privilege is unnecessary because in the court's view, attorney work products may be sufficiently protected in a criminal proceeding by existing hearsay rules. Now, by hearsay rules, the court meant that if a legal opinion or communications provided by an attorney to the client is seized and produced as evidence in a court, then that attorney could still refuse the admission of such work product as evidence into the court by exercising his or her right under law to refuse to testify to confirm the gist of what the article contains. as the writer of that article. However, this decision was heavily criticized by the Korean legal community, as that kind of protection provided by the hearsay rule is quite limited and does not align with expectations of clients and attorneys who are more familiar now with broad protections under attorney-client privilege under US law or common law, for that matter. In fact, one of the criticisms was that the hearsay rule does not apply to communications from a client to the attorney. So even if the client cannot refuse the admission of attorney communications. And another aspect that was criticized was that even if an attorney's communications are not admissible as evidence in court, prosecutors, police, and regulatory authorities can still seize the communications and use those to assist their investigations even before court proceedings takes place. And in practice, that puts a potential defendant at a significant disadvantage. So in terms of fairness and equality, the legal community thought that the protections provided by the hearsay rule were not enough, and that separate ACP privileges needed to be established. Most important of the criticisms, lastly, was that in the event the attorney chooses to testify under the protections provided by the hearsay rule, if the attorney in question chooses to testify and have the work product admitted into evidence in court against his or her professional obligations of secrecy, then the client doesn't have any options and can no longer rely on the hearsay rule for protection. So these are the backgrounds in which the Korean legal community and legislative community today is vigorously discussing the need to establish ACP and work product doctrine firmly under Korean law. Various bills have been proposed by different legislators, some supported by the Korean Bar Association. Similarities are that there is an effort to establish as a rule that no one can request a disclosure or submission of attorney-client communications or attorney's work product prepared for the client unless it is for a very limited exception. The Korean legal community is quite mindful that most OECD member states with sophisticated legal systems have established ACP in their laws, and our community also emphasized the need to align legal protections with global standards. So in sum, privilege is still a developing issue in Korean law, and clients who are involved in Korean litigations do not have, they are aware that they do not have wide protections of some of the legal privileges expected in, say, common law jurisdictions. However, international arbitration is a slightly different creature. International arbitration, also a popular form of dispute resolution in Korea. Now, the interesting thing is, even for Korean parties, the expectations of privilege afforded to those who participate in arbitration proceedings differs quite a lot from Korean litigation. Now, as I mentioned in the outset, in international arbitration, privilege is an issue that always comes up because of the different legal systems at play. Some of the issues include the parties' rights and expectations, professional ethics rules that the respective counsel teams are subject to, the tribunal's discretions and limitations. Those all play a factor in which privilege rules should apply. And to start off, in terms of applicable laws and rules, arbitration rules, neither the Korean Arbitration Act nor the KCAB International Arbitration Rules explicitly address issues of privilege. But this isn't very different from other, the Nusa model law or the other prominent institutional arbitration rules. Most of those do not provide guidance as to which legal privilege rules should apply. They're largely silent or completely silent on the issue of privilege, with the exception of, I think, the ICDR rules, which stipulate that the most favored nation approach is applicable, but that's a big exception. So the Korean law or KCAB international arbitration rules do not provide guidance. So in that respect, there doesn't seem to be a different any grounds for a different expectation to apply here. However, both the Korean Arbitration Act and the KCAB International Arbitration Rules accept that the tribunal has a broad discretion in determining matters of evidence, including the admissibility of evidence, as long as it doesn't go counter to the parties' agreement or mandatory provisions of law. So in that respect, as to parties' agreements, usually parties do not have an agreement on which legal privilege rules would apply. So that usually doesn't provide guidance. However, and then the next step is parties and tribunals look to the arbitration rules or the laws, national rules, which apply, but then usually those also don't provide guidance. And then the last resort is the usually parties and tribunals frequently look to the IBA rules on the taking of evidence in international arbitration. And under those rules, IBA rules, Article 9, they provide certain guidances for the tribunal to exclude from evidence or production any document from production for reasons of legal impediment or privilege under the legal or ethical rules determined by the tribunal to be applicable. And most tribunals have used those rules to apply a broad concept of ACP or work product to accept objections from parties' counsel in excluding certain documents from evidence. And because the parties who are and the counsel involved in international arbitrations are quite aware of arbitration tribunals' tendencies to be respectful to differing legal systems, and the arbitration tribunal's also obligation to treat parties equally and fairly, usually they are much more open and accepting of tribunals who, whether by their discretion or by application of the IBA rules, which is soft law, but by application of these rules, apply a higher protection on documents which would be subject to attorney-client privilege or more stronger protections of legal privilege in other legal systems. And in those cases, in arbitration proceedings that I've been witness to and that I've participated, yes, there have been instances where parties would dispute applicable rules of privilege because their expectations would be different. But even in those cases, the kind of more the experienced counsel, they tend to be respectful of the tribunal's awareness and wariness to apply protections, if strong protections for all parties involved. Usually because it is not a criminal proceeding, and it's usually commercial arbitrations. So commercial interests are at play. And in those situations, tribunals tend to be very respectful of sensitivities and reasons not to disclose. And parties in counsel who have experience in international arbitration are accepting of those tendencies and the reasons why tribunals would act this way. And so they, even for Korean parties and international arbitration cases with Korean aspects, the expectations of parties and counsel are very different in comparison to Korean litigation. So even though under Korean law, rules of privilege are quite limited in comparison to common law and US law, when conducting international arbitration cases in Korea, privilege rules may and likely will apply across the board. Yes. Thank you very much. That's the end of my discussion.
Thank you very much. Thanks, Joanne, for your presentation. So I think we still have like 8 minutes for Q&A. So I just want to remind our participants, if you have any questions, please directly send your questions to me through the chat box. So we already have a couple of questions. So the first question is to Violet. So the question is about the legal principle on the proper law, the applicable law of the arbitration agreement, and in the ANCA case, right? So the question is whether this kind of approach has been adopted in Singapore. And I think I have a follow-up question is, so in your presentation, you asked you presented that we have this kind of 3-stage approach to decide the applicable law of the arbitration agreement. Now the new case came out, and then we have a approach to decide the arbitrability of the dispute, right? So I was wondering whether this approach to determine the arbitrability, to apply both the law in the pre-award stage and our post-award stage will also be applicable or be adopted, will it be adopted in other jurisdictions, especially in the common law jurisdictions such as in Hong Kong? Because you mentioned that there are similar practice in UK, but I was wondering whether you have any observations on how is it adopted or implemented in Hong Kong, for instance. And then for Joanne, there are 2 questions. The first question is that, so you just presented that there are the privilege legislation is very limited, and then very restrictive in Korea, even though in the common law jurisdiction the approach is quite liberal. So you also said in the practice the parties have disputed, right? But I was wondering, so the question is whether the applicable rule on these privilege issues has become one of the grounds that the parties use to set aside an arbitral award in Korea. And the second question is that it seems that to me that there is a gap between what is practicing now and what has been legislated. So I was wondering whether, do you predict that in the near future that Korea may amend their, some domestic law on the privilege aspect, so that to align with the international standard of the disclosure or evidence, etc., in international arbitration more specifically? I think we can just invite 2 speakers to answer this first round of questions. Violet, do you want to go first?
Yes. So in terms of the question as to whether Singapore court has adopted that decision in the UK, I think you can take a look at the judgment in the Singapore court, because I think they're talking about different things. Because ANCA was talking about how to determine the law of the arbitration agreement, where the court said it's a bit artificial to say that the law of the arbitration agreement should always be the law of the seat. So there is actually a preference to adopt the law of the underlying contract. So it's not entirely on all fours with the case in Westbridge, because Westbridge is more about applying the 2-stage test to determine arbitrability in the first place. So it's about asking what law should apply, whereas ANCA is answering the question as to how do we even determine that law? So it deals with different issues, but I think from the Singapore court's approach, I think my short answer would be no, it's not adopted in Singapore.
Yeah, thank you. Joanne, please.
Okay. Just so the first question, I think, is whether any issues of privilege or the application of privilege rules became an issue to set aside an award in Korea. So the short answer is no, not that I'm aware of at least. None of the, I mean, to begin with, Korea is a New York Convention, a signatory state. So New York Convention would apply to awards from signatory states, and under and we are also a very arbitration-friendly jurisdiction. So any kind of rulings which do set aside international arbitration awards are quite publicized, readily known. There are very few. And on the grounds for set aside under the New York Convention countries, I guess the most applicable or relevant ground in relation to privilege issues would be the public policy of Korea. But as far as I'm aware, there have been no judgments from the Korean court setting aside an international arbitration award for a violation of public policy of Korea due to the specific rule of privilege that the tribunal applied. As to the second question, I hope I can answer very shortly. So whether we can predict that Korea may amend a domestic law on privilege to apply perhaps differently in international arbitration. My sense is that I think there is a higher likelihood that Korea will amend its domestic laws to apply a higher level of protection for attorney-client communications across the board, not just for international arbitration. Because for, I think, international arbitration, the protection in practice is already higher, and because of the expectations of and the discretions of the tribunal, but also because I think Korean legislators and the international arbitration community in Korea is also quite well aware that international arbitrations should usually be molded specific to the needs of the parties in the dispute, and they are quite wary of kind of mandatorily regulating procedures to apply in arbitration cases.
Yeah, thank you so much. And perhaps the second round, very short question, briefly, in the interest of time. So I think both Korea, Singapore, and Hong Kong, they're very attractive and reliable Asian jurisdictions, especially international arbitration, where you can see some gaps, in terms of like applying the rule of arbitration, the approach of arbitration to determine arbitrability, and the approach of the privilege. So I was wondering whether you have any thoughts on how we are going to find a conversion point so that, to strengthen collectively, to strengthen Asian jurisdiction roles in promoting international arbitration to be more consistent and coherent, so that we can make sure our Asian jurisdictions are really more attractive than before or than other regions in terms of doing international arbitration. It's a very broad and general question. Yeah, Joanne, do you want to go first and then?
Sure. Just to check that I understand the question correctly. So whether there is anything that the different Asian jurisdictions can do to consolidate efforts to become more of a hub for international arbitration, right? I think, well, I guess the classic response would be, I think, well, for starters, I think everyone understands that Asia is the hot place of international arbitration, for one. Everyone is flocking to the Asian markets for arbitration cases. And second, I think Singapore, I understand, is doing beautifully to consolidate efforts as Korea is also endeavoring to. But I think the most important aspect is to be well known as an arbitration-friendly jurisdiction, for starters, for courts and the legal community in general to be accepting of international arbitration as the final and conclusive method of dispute resolution. Because before, in prior times when that was not established, even for Korean parties, they're always wary of the risk that arbitration awards could be set aside, which then, so that effort. And also, I think concerted efforts by the government, I think in terms of Korea, we're always looking to how to integrate efforts to kind of support our arbitral institutions so that those institutions kind of generally align with the most prominent arbitration institutions so that expectations and services are kind of upgraded across the board.
Yeah, thank you. Violet, do you want to add something on this point?
I completely agree with what Joanne said. I think the question is, what are we trying to achieve consistency for, and what can we achieve consistency on? So in terms of the governing laws, I think in Asia, we're talking about countries with completely different legal systems, such that I think consistency in itself is probably not achievable. But I think there can be consistency in adopting a more pro-arbitration stance. So in terms of policy, upholding arbitral award, despite the errors of law, perhaps, I think that in itself would make Asia as a more attractive spot for arbitration.
Yeah, thank you. Thank you both. I think our time is up, so we are going to end here. I want to thank our two speakers. Thanks for your wonderful presentation. And also thanks to all the participants for joining us today.